I'm not threatening you. Say one more word and that's 30 days. 30 days.
I'm not the one being unethical.
You want to smile about it and laugh about it? Take him back.
I've stated multiple times on the record that I wish to represent myself. Is my social security number attached to this at all?
Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
Welcome back, because somehow this sequel starts with the judge threatening contempt before we've even made it past the opening minute. That's usually not a great sign. For anyone unfamiliar with these cases, contempt of court isn't some empty courtroom threat. Judges have the authority to punish behavior that disrupts proceedings, disrespects the court, or refuses to comply with lawful orders. And judging by how fast things are escalating here, Judge Simpson already knows exactly what kind of hearing he's about to have. The real question isn't whether Thomas is going to argue, it's how long it takes before those arguments start making his situation even worse. Grab your popcorn because this is headed straight toward a collision between courtroom procedure and internet legal theories.
Alright, this is part 2 of this Sovereign Citizen saga, and somehow it's already off to a worse start than the first. He's back in court facing fleeing and eluding, assault on an officer, and driving without a license. So the stakes are real, and instead of adjusting anything, he walks in acting like the same wordplay is about to save him. He's in front of Judge Simpson this time, which is probably the worst possible matchup if you're trying that approach. You can tell right away he thinks he's the smartest person in the room. How many times does it take before someone realizes this strategy isn't working? Let's go ahead and dive in.
Case People versus Thomas Styron. Here we go.
The public defender Otatella on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that, right?
We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here. You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later.
And just like that, we're barely 2 minutes in, and the judge has completely lost patience. Now, some viewers might think the reaction is harsh, but here's the thing. Courtrooms run on order. A judge can't spend all day debating, arguing, or chasing someone around a simple question. Notice what keeps happening here. The judge asks a direct question. Instead of answering it, Thomas pivots into word games, identity arguments, and side issues. Eventually, judges stop seeing confusion and start seeing obstruction. That's an important distinction. Courts will usually bend over backwards to explain procedures, but once they believe someone is intentionally disrupting the process, the gloves come off. Question for the comments. At what point does someone stop standing on principle and start actively sabotaging their own case?
Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. First calls the case of the People versus Styron. Recall. State your name.
My name is Thomas Styron. A living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding third degree?
This is actually a fascinating legal moment. The judge isn't removing him because of what he believes. He's removing him because he refuses to participate in the process required for the hearing to move forward. That's a huge difference. People often misunderstand this. Courts don't punish beliefs, they punish conduct. You can disagree with the government, disagree with the charges, even disagree with the judge, but eventually you still have to answer basic procedural questions. The irony here is that Thomas keeps insisting he wants to represent himself, but self-representation requires cooperation with the exact legal process he's refusing to engage in. It's like demanding to play a game while refusing to learn the rules.
So,
Do you understand the nature of that charge? You just need to answer my question.
for the record,
Take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days! Recalls the case, people of the state of Michigan versus Thomas Styron II. Mr. Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding third degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself.
This may be the most important part of the entire hearing, and it's easy to miss because it's not dramatic. The judge is laying out the reality of self-representation. A lot of people think representing yourself means freedom from lawyers and freedom from legal complexity. It's actually the opposite. Once you waive your attorney, the court expects you to know the same procedural rules, evidence rules, filing requirements, and courtroom standards that trained attorneys spend years learning. And here's the catch. The judge cannot become your legal coach. If you make mistakes, they're your mistakes. That's why lawyers often say the person who represents himself has a fool for a client. Harsh? Maybe. But courtrooms are not designed to teach legal theory on the fly.
I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, And with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
Not even 5 minutes in and he's already bought himself 30 days. Impressive speedrun. It's like he walked in with a plan and immediately set it on fire. You can almost see the moment Judge Simpson decides, yeah, we're not doing this today. Coming back for a third try and still acting confused is wild. At some point it stops being misunderstanding and starts being willful stupidity. There's confidence and then there's whatever this is. These guys always think they're playing chess while everyone else is playing checkers, but it turns out they're just flipping the board.
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I've tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes, sir.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me.
Ouch. This is where the consequences become real. Up until now, everything may have sounded like an argument, a debate, or a clash of personalities. Not anymore. The judge is officially imposing the contempt sentence, 30 days. And what's remarkable is that none of this has anything to do with whether he's guilty of the underlying charges. Think about that for a second. The fleeing and eluding case is still pending. The assault charge is still pending. The license charge is still pending. This extra jail time comes entirely from how he conducted himself in court. It's a powerful reminder that behavior inside the courtroom can create consequences completely separate from the criminal allegations themselves.
Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
So first of all, watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a Sessions QVA trust matter involved in this? Or is my social security number attached to this at all? Go figure.
If there was ever a moment to hit the brakes, this was it. The judge is practically giving him a final warning with flashing lights attached. But instead of backing down, Thomas doubles down. And that's what makes this hearing so fascinating to watch. You can literally see two completely different realities colliding. On one side, a judge focused on procedure, authority, and courtroom order. On the other, a defendant convinced that identity arguments and trust theories somehow override the process. The problem is that courts don't operate on personal belief systems. They operate on statutes, precedent, and procedure. And every time Thomas pushes further, the judge's response becomes more predictable. Here's the takeaway. Confidence can be an asset, but confidence without strategy is just a fast track to consequences. What do you think? Was the judge too strict, or did Thomas bring every bit of this on himself?
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical. Very good.
You'll serve the 30 days. We'll see.